Mwangi Gasheshe? Not present. Okay. So the decision will be read by Lanai on my left.
This is the decision of this committee. The committee hearing is a quasi-judicial body that has the right to vary, uphold, or revoke the decisions of a returning officer, and in doing so has the power to exercise discretion as the circumstances may require. It is the finding of the committee that the circumstances that led to the complainant not appearing before the returning officer before the lapse of the gazetted period were factors beyond the complainant's control. Further, the committee noted that the complainant made every effort to present himself before the returning officer for clearance a day after the unfortunate loss of his father. It is tried law that equity aids the victim. The committee therefore finds and holds that the complainant has advanced compelling reasons and that this is a deserving case for exercise of the committee's discretion to allow the complainant an opportunity to submit his nomination papers and to possibly contest the political office. And these are the orders of this committee. Upon considering the complaint hearing, the evidence is in support thereof, and hearing both the complainant and the returning officer, it is the finding of the committee that the failure of the complainant to appear before the returning officer for clearance was occasioned by factors beyond the control of the complainant. The complainant herein has given compelling reasons to support his complaint, and consequently the committee orders as follows. The decision of the returning officer of Joro constituency rejecting the application by the complainant for nomination to run for Weru Ward or Joro constituency, Nyandarua County, is hereby revoked. The complainant is hereby directed to present himself before the returning officer or Joro constituency within 48 hours from the date of this decision to present his nomination papers for consideration for clearance by the returning officer. For avoidance of doubt, this decision does not constitute an automatic clearance by the returning officer of the complainant to run for the position that the complainant seeks. Whether or not the complainant is eventually registered as a candidate is subject to compliance with all the applicable laws and regulations and shall be determined by the returning officer. No other aspect.
Judgment for complaint number 204, Joseph Oumandonji versus the RO Embakasi West constituency, Shadrach Machanje and ODM party.
Where is Joseph Oumandonji? Shadrach Machanje Namuli? Okay. All right. Because of the importance of this decision in terms of jurisprudence, we will read it in full. ODM party? Anybody representing ODM party? I don't want to point out anybody I know. Anybody representing ODM party? You don't want to hold brief?
No, Jack.
Okay.
I don't have instructions.
Okay. Please transmit this information to the party.
That's in order.
Yeah, I'll just read a little quickly so that we can make headway. The complainant is a member of the second respondent, that is the ODM party, and the current member of County Assembly for Moja 2 in Embakasi West constituency within Nairobi County. The complainant seeks for the revocation of the clearance of the first respondent to vie in the upcoming general election on account that such clearance was in breach of a then existing order barring the nomination of the first respondent and second respondent's party candidate in the electoral area. The committee has been asked to revoke the decision of the third respondent, that's our returning officer, clearing and registering the first respondent as a candidate to vie in the upcoming general election. Analysis. The present complaint was heard on 18th June 2022. Mr. Makori and Mr. Ngala counsel appeared for the complainant. It was a counsel submission that clearance of the first respondent ignored orders of the PPDT and thus the clearance should be revoked. It was counsel submission that as an outcome of the proceedings in PPDT, the second respondent was barred, that's ODM, was barred from forwarding the name of the first respondent for clearance, and therefore the second respondent was in contempt for forwarding the name to IEBC. The complainant's contention that the first respondent was not qualified to be the nominee for the second respondent under the second respondent's party rules. The third respondent appeared in person and confirmed that she received the judgment of the PPDT before the clearance process commenced and sought the advice of the IEBC legal team. The third respondent confirmed that she only proceeded to clear the first respondent after the second respondent, that's the party, re-forwarded his name with a new nomination certificate and confirmation of the IEBC legal team that she could proceed and clear the candidate, the aspirant. The first respondent was eventually cleared on 5th June and the complainant appeared in person. The third respondent further stated that she was served with numerous letters and orders and she needs directions on what to do in the circumstances. Mr. Okach, appearing on behalf of the first respondent, counsel submitted that it's not in dispute that PPDT gave orders on 31st May for fresh nominations to be conducted by the second respondent. It was counsel's contention that following the PPDT orders, the second respondent conducted direct nomination of the first respondent and he was issued with a new nomination certificate. Counsel further submitted, and it is further not in contention, that the PPDT issued further orders on 14th June 2022 and which orders were however stayed by the High Court on 16th June in High Court Appeal number 413 of 2022, where IBC is a party. It was counsel's view that on account of the High Court stay order which binds this committee, the situation that obtains that the first respondent remains clear. The second respondent was represented by Mr. Juma. Counsel associated himself with the submissions made by Mr. Okach and further reiterated that everything stems from the PPDT decision of 22nd May 2022 and the second respondent has complied. It was counsel's further submission that the third respondent cannot be faulted as she relied on the documents before her, which documents were provided by the second respondent. Further, counsel was the view that the hierarchy of courts should be taken into consideration by the committee, and the middle ground for the committee to take is to cede jurisdiction to the High Court to deal with the matters at hand. The complainant in rejoinder insisted that the order of 14th June was stayed by the High Court. The judgment was not that the first respondent is still bad. So this is a decision of the committee, and I'll go a little slower. The committee has considered the complaint, the pleadings for and against the same, as well as oral submissions made by counsel before this committee. During hearing of the matter, the committee was reminded of the hierarchy of courts under Article 165(6) of our Constitution. We understand counsel to be saying that this tribunal must decline to exercise the jurisdiction on account that the High Court is now seized of the matter. It is striking that jurisdiction, especially when questioned, must be considered as a preliminary issue. We rely on the jurisdiction discussion in the celebrated case of the Lilian S, motor vessel Lilian S and Caltex Oil, 1989, which is well known and does not require extensive discussion before this committee. To this end, the first Respondents' Council directed the committee to the order issued by the High Court on 16th June in High Court Civil Appeal E413, that is Shadrach, Machanje Namunu versus Joseph Ouma Ndonji, which order read in part, an order of stay of execution of the ruling of Honorable M.L. Odongo, Tororei Timothy Kiprotich, and Lydia Wamboi delivered on 14th June 2022 is to last until 30th of June 2022. To our understanding, what was stayed by the High Court was the PPDT ruling of 14th June 2022. However, to the committee, it appears that the judgment by the PPDT of 14th May is still in force, and we note particularly that the said judgment of the PPDT at Order C barred the second respondent, that's ODM, from forwarding the name of the first respondent, quote, as its nominee for the seat of MCA Embakasi West constituency in respect of the coming general election in August 2022. The legal effect of the PPDT judgment, without clarification, appeal, or stay of the same, is that then the name of the first respondent should not have been forwarded to IEBC. The committee therefore finds itself in a legal quagmire. To our understanding, the High Court has stayed the ruling of PPDT that provided for the recognition of the complainant as the new duly nominated candidate of the second respondent in the upcoming general election, while further, the judgment of the PPDT which barred the second respondent from forwarding the name of the respondent of the first respondent to IEBC at the same time remains in force. On account of the above, the committee draws the following conclusions. The ruling of the PPDT having been stayed, the complainant cannot be deemed to be the duly nominated candidate. On account of the fact that the judgment of the PPDT barring the forwarding of the name of the first respondent to IEBC remains in force, the decision of the third respondent to clear the first respondent to bar did not take into account the PPDT judgment and cannot be revoked. The committee is aware that the effect of the above conclusion is that the second respondent, that the party, will be without an MCA candidate in the stated electoral unit. Though no arguments were made before us to this effect, if any, where the second respondent, that is ODM, finds itself without a candidate, will find it proper, in line with IEBC's role under Article 88, to facilitate the election process to consider this question. The committee relies on the discussions and determination of the High Court in the celebrated case of Diana Katie Kilonzo versus the Independent Electoral Boundaries Commission and 10 others, which is a 2013 Commission decision. In that case, the High Court is down. In our view, the growth of the constitutional imperative cited above. We think that the political process in Kenya can only be robust if political parties have an opportunity to participate. Parties' legitimate expectation to field a candidate, but such legitimate expectation cannot be limited. In that case, the candidates of Ms. Kilonzo, the Wipers' legitimate expectation remains inviolable, except as it may otherwise be affected by law. So I'll skip that and go to the paragraph 3 of that decision. The Constitution is about opening space for citizens so that they can liberally express themselves within its confines. That is the promise of the Constitution, which underpins the legitimate expectation of the Wiper Party. One of the cornerstones of exercising political rights is the right to elect a candidate of one's choice on the platform of any of the lawfully registered parties. This goes hand in hand with the right of citizens to participate in the affairs of a political party and to campaign for a political party or cause. Having said that, the High Court concluded as follows in the following case. In that case, we agree with the sentiments of the 5-judge bench in the integrity case above. Consequently, it is our finding that limiting Wiper Party political rights will be inimical to the exercise of democratic rights and freedoms of its members. We will go further and add Article 3 to the Constitution, which clearly provides the people may exercise their sovereign power either directly or through their democratically elected representatives. In our view, so long as the political power has not contravened any law, there is no reason to deny it the opportunity of fielding a candidate in any election. So, with those in mind, the committee, guided by those sentiments of the High Court, and in exercise of extreme caution, and thereby granting benefit of doubt to the second respondent, that is the ODM party, the committee, I'll start again, my apologies. Guided by the above sentiments of the High Court, and in exercise of extreme caution, and thereby granting the benefit of doubt to the second respondent, that it has indeed done nothing outward to precipitate the situation that has now befallen it, we are minded to give the second respondent, that's the ODM party, the chance to field a candidate to vie as an MCA in the concerned electoral unit in the upcoming general election. In the premise, the committee makes the following orders. The decision of the third respondent clearing the first respondent, that is the person who got nominated for ODM, to vie for the position of MCA Umoja 2 Embakasi Ward West, Umoja 2 Ward Embakasi West constituency in the upcoming general election is hereby revoked. Save to the extent provided in the order above, the complaint by the complainant is also dismissed. The effect of that is both the complainant and the first respondent cannot be cleared to run for ODM in that ward. Consequently, the second respondent, ODM, is hereby allowed to nominate and forward the name of an alternative, in bracket and underlined, in bold and underlined, an alternative candidate to IEBC for clearance for the position of MCA Umoja 2, Ward Embakasi West constituency. The newly nominated candidate shall appear before the returning officer for clearance within 72 hours of the date of delivery of this decision. For the avoidance of doubt, this decision does not constitute an automatic clearance of the alternative candidate, whose name will be forwarded as directed in paragraph C above by the returning officer in Embakasi West constituency to vie for the position of MCA Umoja 2 Ward. Whether or not the same alternative candidate is eventually registered as a candidate is subject to compliance with all applicable laws and regulations. We make no orders as to costs, and we wish to cut here.
Much obliged, Mr. Chair.
Call out the next one.
DRC complaint number 316 of 2022. Winnie Naliaka versus the returning officer in Embakasi West constituency.
So this one will be read by Commissioner Justice Lanai.
This This is the decision of this committee.
Is this yours? Is this yours? Is that yours?
Yeah.
This one is yours. Then so use that one. It's okay.
We start by making clarification that this matter was first filed as complainant number 156 of 2022 by the complainant hearing. However, during the filing process, the complainant gave the wrong contact details, and therefore the registry was unable to reach her and notify her of the hearing. That complaint was therefore dismissed for want of prosecution after it was called out several times and the complainant didn't appear. It was until when the complainant came to follow up on the matter that this mistake was realized. To rectify the situation, the complainant was therefore allowed to file this complaint so that the committee can consider it on its merit. Going back to the merits of the complaint, the gist of the complainant's grievance is that she was denied a chance to present her nomination papers on the grounds that she was late. She, however, contends that she arrived at the registration center right on time, just a few minutes to the deadline, and therefore she should have been cleared. It was considered by the complainant that she was meant to appear before the respondent on 5th June 2022, but she failed to do so. The complainant has not given any reason for her failure to appear before the respondent on the appointed date. Her only excuse was that she did not pick the date of 5th June 2022. The date was allocated to her by the respondent. On this issue, the committee understood the explanation given by the respondent that the complainant only wrote her name on the schedule during the pre-nomination meeting, but failed to pick any of the available days to present her papers. And therefore, the respondent exercised his discretion to allow the complainant the 5th June 2022. The complainant confirmed that indeed she knew of the allocated date. While it is understandable that the complainant might have been held up on the appointed date and was therefore unable to appear before the respondent on that day, a prudent person would have reached out and tried to mitigate the situation. The complainant failed to do so. She was unable to confirm that she indeed communicated to the respondent that she would not appear on the 5th June 2022 so that she could be rescheduled to another date. While she claimed that she actually reached out to the respondent, there is no evidence placed before us to confirm this. This was important considering that the respondent denied that the complainant ever called him. It is regrettable that the complainant did not take any initiative to ensure that she was cleared to contest, only to come out guns blazing at the end of the process, despite all the opportunities she had to get cleared. All the complainant did was to sit pretty, wait until the last day at 4 p.m., and take a brisk walk to the registration center in the hope that the respondent would be waiting for her. Even then, she did not have all the requirements. The complainant told the committee that she was not with her seconder and proposer, who was still, in quotes, in the vicinity of the registration center. End of quote. At the time she appeared before the respondent, this was already past the deadline. From her behavior, the only conclusion one can arrive at is that the complainant was not keen on contesting in the 9th August 2022 elections. We also find the complainant to be a dishonest person. She denied that she never attended the pre-registration meeting, but was unable to explain when she picked her nomination papers when the respondent said that she picked the documents at the meeting and her name was in the attendance register of the said meeting. To further demonstrate the sheer lack of seriousness on the complainant's part, she blames her lateness on the fact that she did not know that the exercise will end at 4 p.m. since she did not attend the pre-registration meeting, where she did, and as we have already stated, found that she did. She also claims that she wrote in the registrar that she arrived at the registration center at 4:20 p.m. because she was instructed by the respondent to do so. Regulation 2 of the Elections General Regulation 2012 defines close of nominations to mean 4 o'clock in the afternoon of the last nomination day for respective elections. Gazette Notice number 435 on 14th, number 14, Nairobi, published on 20th January 2022, the Gazette Notice states clearly that the days for nomination of political party candidates and independent candidates for the county assemblies shall be between Wednesday 1st June 2022 and Tuesday 7th June 2022. The Gazette Notice further states that the nomination papers shall be delivered by candidates to the respective returning officers between the hours of 8 o'clock in the morning and 1 o'clock in the afternoon, respectively, and between the hours of 2 o'clock and 4 o'clock, respectively, in the afternoon at a place designated by the Commission. One will expect a person of the caliber of the complainant who is seeking to hold such an important public office to have been aware of these timelines as stipulated in the Gazette Notice. It was clear that she had no idea of the same. And in Protas Wafula versus Independent Electoral and Boundaries Commission, the court stated as follows, and we have included the quotation. To the committee, the behavior of the complainant clearly shows that she did not take the registration process seriously. She could not explain to the committee the reason why she could not appear before the respondent on 5th June 2022 at the appointed time for clearance. She also did not make sufficient efforts to communicate this to the respondent. To make matters worse, and as she admitted during her testimony, the complainant waited until 4 minutes to the deadline, 4:56 p.m., on the last day to appear at the registration center. A clear indication that she was not keen on being cleared. As we have noted in the foregoing, the complainant was not honest when she claims that she arrived at the registration center before 4 p.m. but was not cleared because other aspirants were still being cleared. The respondent was justified in declining to accept her nomination papers after she arrived at the registration center past 4 p.m. Regulation 43(2)G of the Elections General Regulations recognizes that a returning officer can reject nomination papers on the ground that the documents were time-barred, which was the case in this instance. We are therefore inclined to agree with the testimony of the respondent that the complainant did present herself at the registration center after the lapse of the period for clearing aspirants for the position of member of county assembly. The respondent was thus justified in rejecting the complainant's nomination papers. And these are our orders. In view of the foregoing, we find that this complaint lacks merit, and the committee upholds the decision the decision of the respondent, for the complainant to contest for the position of member of county assembly, Mihango Ward, Nairobi County. The complaint is hereby dismissed with no orders as to cost.
Next matter, please. Chilongo. Excellent. Daigo Gasheru. Who was Mwendo Munene? Interested party. Who was the assisting counsel dealing? Catherine. Is that the complainant behind there? Oh, okay. All right. This will be read out by Commissioner Masit to the decision. Decision, paragraph 15. Sorry, if you will skip here. Okay, we get the Kilonzo quotation. Don't skip it because they know it. Yes.
The decision of the committee. From the testimony and evidence adduced during the hearing, it is the committee's finding that although the complainant attempted to rectify the errors pointed out by the first respondent on 5th June 2022, he failed to do so and cannot now cry foul for his own omissions. The complainant has not demonstrated to the committee that he was indeed not accorded a fair hearing by the first respondent, or that he made any effort to rectify the issues pointed out by the first respondent as he is purporting to do before the committee. The committee therefore finds that the county returning officer, Mombasa County, was justified in law to reject the complainant's nomination papers on 5th June 2022 in accordance with Regulation 43.2 for failure to fulfill the requirements for the complainant's elective position as stipulated under the laws and regulations cited herein. Further, the committee notes the invitation to find on the issue of compliance or lack thereof by the complainant with Chapter 6 of the Constitution, and in particular with regard to the supposed appeal. The committee, however, finds that this is not the relevant forum to address issues around competence or validity of an appeal, and the committee has no jurisdiction to determine the competence or validity of an appeal that is not placed before it. That being said, the committee now turns its attention to the interested party, who has reiterated its legitimate expectation to field a candidate for an election as provided under the Constitution and other laws. The committee is guided by decision of the High Court in petition number 359 of 2013, that is the case of Diana Kethi Kilonzo and another versus IEBC and others 2023, in which the court held, I leave the quotation, you'll find in that case. In our view, as long as a political party has not contravened any law, there is no reason to deny it the opportunity of fielding a candidate in any election. We note that Wiper Party may not have been vigilant when it came to the fielding of Mrs. Kilonzo. I leave the rest. The committee notes that from the evidence and testimonies before it, the process that led to the registration of the complainant as a candidate is not in question. There is no accusation or allegation of any wrongdoing or contravention of any non-law by the interested party. The committee finds and holds that under the circumstances, there is no reason to deny the interested party the opportunity to realize its legitimate expectation as held in the Kethi Kilonzo case. Our orders. In view of the foregoing, this committee finds and holds that the complainant has not demonstrated compelling reasons to warrant an extension of time to comply with the set nomination requirements, as all the circumstances resulting in the rejection of the nomination papers were within the complainant's purview and control. The committee finds and holds that the complaint herein lacks merit and it is hereby dismissed. Consequently, the committee hereby orders as follows. Consequently, the committee hereby orders as follows. The decision of the county returning officer, Mombasa County, rejecting the nomination of the complainant is hereby upheld. A declaration be and is hereby issued that the first interested party has a legitimate right to nominate a candidate to contest for the position of governor, Mombasa County, in the 9th August 2022 general election. Should the interested party deem it fit to nominate an alternative candidate in place of its now disqualified nominee, the complainant, the said new nominee, shall present his oral nomination papers to the county returning officer, Mombasa County, within 72 hours from the date of this decision for possible clearance and registration as a candidate for the position. For avoidance of doubt, this decision does not constitute an automatic clearance by the county returning officer of the interested parties alternative nominee to run for the position of county. Let me repeat that one. For avoidance of doubt, this decision does not constitute an automatic clearance by the county returning officer of the interested party's alternative nominee to run for the position of county governor, Mombasa County. Whether or not the new nominee is eventually registered as a candidate is subject to compliance with all the applicable laws and regulations as shall be determined by the county returning officer. No orders as to cost. It is so ordered.
I hope your colleague will have similar sentiments. Okay, and proceedings? Okay, all right. There are just a few typos to be done. Allow us to do that, and you will get, I think, Salome, tomorrow, together with the proceedings. 11 o'clock? Salome? 11. Okay? All right. Okay, okay, thank you. The candidate, we wish you well. Okay? We wish you well. call up the next matter.
There's of number 319 of 2022.
This will be read out by Commissioner Nyangai on my. Page 4. Kusu.
Kuso? Okay. Thank you. Thank you.
So, before you do, are you appearing today as advocate or complainant? Or complainant's advocate? In which capacity are you appearing?
I'm appearing as both.
As both complainant, advocate, and complainant's advocate?
Yes.
We wish you well. Okay. Yes.
My name is Delbert Ochola.
Delbert.
I have requested to call brief for Mr. Jackson to run for the second respondent.
That's the political party. Thank you. Commissioner?
This is the decision of this committee. From the outset, we note that the eligibility of the first respondent has been litigated from the Political Party Disputes Tribunal in complaint number E078 of 2022. The High Court in Election Petition Appeals number 7B of 2022 and is currently before the Court of Appeal, MHA3, MHA4, and MHA6 lacks jurisdiction to entertain the complaint. Without prejudice to the above and on the merits of the complaint, the committee finds as follows. Whereas the complainant availed the annexures to his supporting affidavit, it is the finding of this committee that it is not sufficient proof of membership of the first respondent in the Jubilee Party. The complainant did not avail to this committee any evidence from the ORPP on the membership of the first respondent as at 26 March 2022. Under Section 34 D and A of the Political Parties Act, the ORPP is the custodian of the registrar of members of political parties, since one of its functions is to, in quotes, keep and maintain a register of members of registered political parties, end of quote. Under Section 107(1) of the Evidence Act, whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. And when a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. It is the finding of the committee that the complainant has not discharged his burden of proof on his allegation that the first respondent was not a member of the ODM party as at 26 March 2022. Whereas the first respondent bears no burden to prove this membership to the ODM party, he has nevertheless exhibited before this committee a copy of an official receipt number 42368 on payment of life membership fees in ODM party as from 23rd March 2022. You can look at the pages 113 of the first respondent's reply affidavit. This defeats the complainant's allegation on the first respondent's membership in Jubilee Party. Accordingly, assuming that the committee had jurisdiction over the complaint, the complainant has not proved his allegation to the required standard of proof. Balance of probabilities to warrant the orders sought. And these are our orders. the committee finds and holds that the complainant's complaint herein lacks merit and is hereby dismissed, each party to bear its own cost. It is so ordered.
Kusa?
Most obliged.
Yeah.
I will be praying for a copy of the judgment, certified copy. Shall I proceed?
You will get that in the course of the day tomorrow, and we wish you well ahead.
Most obliged.
Okay. But we agreed wearing a red T-shirt does not make you a Jubilee Party member, isn't it?
I'm also
It's okay.
I'm also shocked that the committee is trying to say that it doesn't have jurisdiction and going ahead with the merits of the case.
We said without prejudice, if you listen,
Yes.
without prejudice.
prejudice,
So that in the event
Yes.
the High Court says we have jurisdiction, then they will look at the consideration of the other matters.
In the famous case, as you have stated,
Yes.
also, the committee finds that it doesn't have jurisdiction, it ought to down its tools.
We will down our tools when the High Court tells us to do so. But thank you.
Most obliged.
Thank you, Mr. Kuso. Which one is not signed? This one.
GRC complaint number 65 of 2022, James of the National Returning Officer.
James Room. Yes. True. They're over. We will treat now. I'll come with this. Yes. Yes, this will be ready.
The matter. Ochola, I do brief for Mr. Moses to pay for the respondent.
Ochola. So this young man was running, was an aspirant for presidency as an independent candidate. He told us his life story. He's 31 years old. He started harboring this ambition when he was 11 years old, and he has put everything else aside for it. He is a very, very interesting young man with great dreams, and one day, if not today, we hope that those dreams, Mr. Kamau, will come true for you. It is in that context that we give this decision. And being a presidential complaint, we propose to read all of it. You may sit if you wish, or you may stand if you wish. Good. The complainant herein is an aspirant for the presidential seat in the forthcoming 9th August 2022 general election as an independent party. The complainant is aggrieved by the respondents, that's the returning officer, national, decision to reject his nomination papers, which decision the complaint claims was not only in contravention of the Constitution, but also a violation of the complainant's legitimate expectations as well as the right to fair administrative action. The complainant, via his complaint dated 6th June and filed on 7th June 2022, detailed the supposed actions, omissions, and decisions of the respondent that culminated to the complaint herein. The matter came up on 17th June 2022 for hearing when the complainant appeared in person. On the other hand, Mr. Moses Kipkoge, advocate, appeared for the respondent. The complainant commenced with a brief introduction of himself before the committee, detailing his aspirations and some of the ideologies that he seeks to advance should he be elected as the President of the Republic of Kenya. Turning to the substance of the complaint hearing, the complainant testified that he had obtained all requirements that were required for clearance as a presidential candidate. He then sought to introduce some of the documents as evidence before the committee, but the committee noted that the complainant had not sworn an affidavit to support of the complaint. It is worth noting that at this juncture, the complainant took an oath as a Christian so as to allow him to adduce evidence accordingly. The complainant testified that he appeared before Mr. Wafula Chebukati, the respondent herein, being the presidential returning officer on 2nd June and 3rd of June 2022, to present his nomination papers for clearance. Upon perusal of the document presented by the complainant on 2nd June 2022, the respondent noted that some of the requirements had not been met. It was the complainant's testimony that he was informed by the respondent that he had attained the required minimum number of supporters in 23 counties out of the 24 counties, out of the required 24 counties. The complainant indicated that he had the list of supporters for the remaining county in a compact disk in 3 different Excel files. On submission of the same for verification, he was requested to combine the 3 Excel files into one. The complainant argued that he complied with the directive and combined the Excel files as required. It was the complainant's contention that upon compilation of the Excel files, he returned to the respondent for confirmation of the same, but the respondent declined to check the documents which he, the complainant, had in a compact disk. The complainant submitted that the respondent acted in bad faith and failed to administratively facilitate him to exercise his political rights as envisaged under Article 83(3) of the Constitution. The complainant argued that Mr. Moses Sunkuli, the acting DVREO of IEBC, who swore the replying affidavit in response to his complaint, was a stranger to these proceedings, and he, that is Mr. Sunkuli, was not aware of the matters that transpired between the complainant and the respondent. The complainant was confident that he had achieved the required threshold for the supporters as required and all other requirements to be cleared to run for office of president. The respondent's counsel, Mr. Kipkoge, submitted that Mr. Sunkuli had demonstrated his authority and capacity to respond to the complaint in paragraphs 2 and 3 of his replying affidavit. Counsel argued that on both occasions, when the complainant appeared before the respondent, he had not met the requirements for the minimum number of supporters required for his elective seat. Therefore, the issue before the committee was a request by the complainant to submit the list of supporters outside the stipulated timelines. Mr. Kipkoge submitted that on 2nd June 2022, when the complainant appeared before the respondent to submit his nomination papers, his application was rejected due to lack of adequate number of supporters. The complainant was then given another date to enable him to comply, but on the return date, the complainant had still not complied. Counsel submitted that during the first appearance on 2nd June 2022, at the point of validation of the list of supporters submitted by the complainant, the respondent made the following findings, and there are 7 findings which were made, but I'll read them. That the total number of compliant lists of supporters per county in the submitted soft copy were 22 only. That the total number of compliant lists of supporters per county in the hard copy was 17 only. The total number of compliant lists of supporters per county in soft and hard copy of at least 2,000 were 9 only. Several identity cards were duplicated. Several Huduma numbers were among the identity cards provided, and some of them were duplicated contrary to the requirements of the law. Several party registration forms were among identity cards provided. Some of the identity card numbers presented on the supporters sheet did not tally with the ones in soft copy, for instance, Kajiado constituency. 7. The aspirant was given another chance to bring additional identification documents of supporters in soft and hard copy, but copies of the identification documents could not be found in the soft copies provided. On the return date, the complainant's documents were still not compliant, as they still showed similar discrepancies. It was therefore counsel's submission that the complainant's nomination was validly rejected for non-compliance. The process of rejection of the nomination was procedurally fair and compliant with the provisions of Article 47 of the Constitution. Further, counsel submitted that the complainant had not advanced before this committee any compelling reasons why he should be allowed to submit his nomination papers outside the prescribed timelines. Article 137 of the Constitution, Kenya 2020, lays out the qualifications for election as president. Particularly, Article 137(1)(d), which is replicated in Section 23(1)(d) of the Elections Act, states as follows: a person qualifies for nomination as a presidential candidate if that person is nominated by not fewer than 2,000 voters from each of a majority of the counties. From these provisions, it is notable that the issue of supporters is both a constitutional and statutory threshold. Regulation 18 of the General Regulations 2012 then provides and prescribes the form and manner of presenting the said supporters in compliance with the above stated provisions as follows. We have listed them, indicated that the sheets of paper have to be serially numbered, each have at the top in typescript the wording at the top of Form 12 and shall be accompanied by copies of the identification document of the voters referred to above. This therefore means that simply collecting signatures or submitting the list of supporters is not adequate by itself. The aspirant has to submit the said list in the form and manner stipulated in Regulation 18 of the 2012 General Regulations. This committee has looked at the case of Jimmy Wanjigi versus Wafula Chebukati, DRC complaint number 86 of 2020, which held as follows. Obtaining 2,000 supporters in at least 24 counties but failing to abide by the other requirements outlined above vitiates the registration process. Regulation 18 of the General Regulation is a law. It aids in the enforcement of Article 137(1)(d) of the Constitution as read together with Section 23(1)(d) of the Elections Act. Hence, it cannot be wished away and compliance therewith is not optional. With this understanding in mind, and from the testimonies and evidence adduced before the committee, including its own admission, it is not in dispute that the complainant submitted an insufficient number of supporters on both occasions when he appeared before the Presidential Returning Officer. The required threshold, as well as the form and method of submission, was not met by the complainant. Regulation 43(2)(a) provides the reason why a returning officer can hold a nomination paper invalid. Regulation 43(4) of the General Regulations provides that where a returning officer decides that a nomination paper is invalid, the returning officer shall record that decision and the reasons thereof on the nomination paper, add his or her signature thereto, and return the invalid nomination paper to the candidate or its presenter. The respondent, in rejecting the application for nomination of the complainant, indicated on his copy of Form 12 the reasons for the rejection, which were inter alia, failure to provide the list of supporters in Excel format, a mismatch and insufficient supporters, and upon resubmission, the candidate is not compliant with the submission of supporters. Evidently, the complainant was not compliant with the law, and the respondent did not err in rejecting the complainant's nomination papers. We note that the complainant's averments and the respondent was not administratively facilitative of the complainant's rights and did not accord him an equal opportunity as other candidates who he alleges were given more time to meet the registration requirements. The committee finds the IEBC has discretion to prescribe procedures to be followed in carrying out various exercises, including the process of registration hearing, even within the statutory timelines. The committee is guided by the case of Republic versus IEBC ex parte Peter Solomon Gishira 2017, where the court relied in the case of KRA versus Meginya Salim Morgani, Civil Appeal number 108, where the Court of Appeal delivered itself as follows. There is ample authority that decision-making bodies other than courts and bodies whose procedures are laid down by statute are masters of their own procedures. Provided that they achieve the degree of fairness appropriate to their task, it is for them to decide how they will proceed. Gazette Notice number 434, published on 20th January 2022, the candidates intending to be nominated to contest for the position of president were to present their papers to their respective returning officer between Sunday 29th May 2022 and Monday 6th June 2022 between 8 and 1 p.m., 8 a.m. and 1 p.m. and 2 p.m. and 4 p.m. respectively, pursuant to the above stated came in the procedure that will be followed in effecting the registration of candidates, allocating, extending or denying time or such other administrative procedures, and therefore cannot be considered unfair, provided that in effecting the same, the appropriate degree of fairness is achieved. In any event, the complainant's nomination papers were rejected on 3rd of June. The complainant still had about 3 more days to the lapse of the gazetted period to correct the errors pointed out by the respondent and resubmit his nomination papers. The complainant did not in any way demonstrate that he requested to correct the errors or that he attempted to resubmit his nomination papers within the said gazetted period, and presumably the complainant chose to abandon the process. This, therefore, is the decision of the committee. The committee is of the considered opinion that the responsibility to comply with the requirements for nomination for any elective seat, including that of the presidency, as well as the gazetted timelines, lies with the aspirant. The committee has considered the evidence adduced and the submissions made by both parties and finds as follows. The complainant did not have a sufficient number of supporters as required by law to qualify for nomination as a presidential candidate. The complainant did not comply with the prerequisites for clearance and registration by the respondent to vie for the position of the president in the forthcoming general elections to be held on 9th of August. The complainant has not demonstrated compelling reasons to warrant an extension of time to comply with the set nomination requirements, particularly the required list of supporters, as all the circumstances resulting in the rejection of the complainant's nomination papers were within the complainant's purview and control. The presidential running officer, the respondent herein, was therefore justified in law to reject the complainant's nomination papers for failure to meet with the requirement for the complainant's elective position as stipulated under the laws and regulations cited herein. This, therefore, are our orders. The committee hereby upholds the decision of the presidential returning officer, the respondent herein, rejecting the nomination of the complainant to contest in the presidential election to be held on 9th August 2022. The complaint herein lacks merit and is hereby dismissed with no orders as to costs. It is so ordered. Yes. Mr. Kamau, this is not the end of the road. Age is on your side. Be better prepared this time. The road to Jerusalem is filled with many, many thorns. This could be one of them. Let this not kill your spirit. The spirit that you started almost 14 years ago, let it still go on. And we wish you well. Okay? You will get a copy of this decision together with proceedings by 11 o'clock tomorrow, once we are done with the typos therein. Do we have another one? So we will break shortly to go finish with the other judgments. We will be back in 10 minutes with the remaining judgments. Yes, yes, sir. Sorry? Yes, which one is that? 204 is which one? We have read it. Yes, we have read it.
It was read early before you came because you were here by 3. So.
Oh, I'm sorry about that, but it is ready. You will be given here, at least you'll be told once we break what the decision was, but the corrected version can be collected tomorrow. Our apologies about that. Is this the matter for Umoja 2?
Yes.
Yes, the matter for Umoja 2. Yes, the matter for Umoja 2, unfortunately, sorry? We've just read it. Let me give you the history of it. The matter for Umoja 2, we have disqualified the complainant and the first respondent and given the party a chance to nominate a new candidate who shall appear before the RO within the next 72 hours. Okay? So we'll take a break for 10 minutes. Let's bow. Let's go.
All of them are being disqualified. I think it will be what I said, the video is admitted to 6 hours. That's what happened. It is a big 6 hours. So you guys have to work 6 hours.
But you can
So now really I'm sorting out.